We are Legally Sis. Welcome to our podcast.
The information provided in the show is for general informational purposes only and should not be construed as legal advice on any subject matter. No attorney-client relationship is created between you and Duran Schultz Law.
So we have this client in our office whose mother has passed away in 2021. She has siblings in abroad and some are in the Philippines. The mom has left a considerable amount of properties under her name, and then the children, as the heir, would want to settle the properties amicably between themselves. So, for today's discussion, we're going to discuss about extrajudicial settlement.
Okay, before we discuss extrajudicial settlement, and I'm assuming there should be a judicial settlement of estate also, let us define what is an estate.
Hi! Welcome to Legalism.
Yes, I'm Attorney March.
And I'm Attorney Wen.
Welcome to our podcast.
Okay, going back to your question as to what is
An estate.
an estate. So, an estate is comprised of the properties of the deceased person, whether it's a real property or personal properties involved.
So you said that this would be a discussion of extrajudicial settlement of estate. What falls under extrajudicial settlement of estate versus judicial settlement of estate?
Extrajudicial, this means that the parties or the heirs involved have come into an agreement whereby they're going to settle the estate between themselves, meaning that there is no disagreement. If there is a disagreement, then you go to the judicial remedy.
How about if there is a last will and testament?
Okay. So what are the requirements of the extrajudicial settlement? So one of which is that the deceased or yung namatay did not leave any last will and testament.
Yeah, because if the deceased would have left a last will and testament, the remedy would be different.
Yes, you have to go to the court in order to have that last will and testament probated.
Okay, you mentioned the party should be willing to amicably settle. The second, there is no last will and testament. Is there a third one?
Yes, the deceased should have no debts
Mhm.
that he or she has left.
Alright.
And then if the parties or the heirs are minors, they should be represented or well legally represented by adults.
Okay, so who should be the parties of an extrajudicial settlement?
When you say extrajudicial settlement, the parties here are the legal heirs of the deceased person. It is different if the party or the heir is just a sole heir, meaning mag-isa ka lang. So the document will be a deed of self-adjudication. If there are several heirs, then the document will be extrajudicial settlement.
So who are involved in an extrajudicial settlement of estate?
The persons who are involved in the extrajudicial settlement agreement are the heirs. So these are the legal heirs. When you say legal heirs, these are the children or the spouses left, either the husband or the wife, if there is any parents that are still living, or the siblings of the deceased person.
Yeah, but we have to take note if there are already children, then the parents are already removed as an heir.
Yes, exactly.
So this will also include illegitimate children, right?
Yes, it also includes illegitimate children. But we have to differentiate if the heir is a sole heir. When in that instance, you will have to execute a self-adjudication document.
Right. Affidavit of self-adjudication.
Yes, compared to extrajudicial settlement of agreement.
Okay, so there are several parties. There is no last will and testament. The parties are willing to extrajudicially settle. There's no debt. What's next?
Okay. After the parties have concluded or agreed to make this extrajudicial settlement, and then complying with all the requisites involved, you have to have your extrajudicial agreement published in a newspaper of general circulation.
So for those parties with like our client right now multiple properties, do you have to execute extrajudicial settlement of estate per property?
No, it's actually advisable for the parties to include all of the properties of the deceased in one document.
So if there are several properties involved, where do you file the extrajudicial settlement of estate?
Generally, you file your extrajudicial settlement at the place where the decedent or residing at the time that he or she died.
Okay, how about if that person is living abroad?
Okay, if the person is living abroad, your extrajudicial settlement will have to be filed before the main office of the Bureau of Internal Revenue, which is the RDO 39 in
Yes.
Quezon City.
Correct. So what are the documents the heirs should be collating to come up with an extrajudicial settlement?
Okay, generally, or the most common one is the birth certificate, of course. This is in order for the parties to, or it will be actually easier for the BIR to trace who are the heirs of the deceased person.
Yeah, I remember the BIR would sometimes even ask for a family tree if it involves multiple deaths.
Yes.
So aside from the birth certificate, any other PSA document?
If the heir, or if one of the heir is a spouse, then generally the marriage contract of the party with that deceased person.
And of course, you have to show the death certificate of the decedent just to prove that that person already died. So you mentioned we have to collate or list down all of the properties that were left behind. So is there any taxes that we need to pay or the heirs will have to pay?
Yes, the heirs are bound to pay the estate tax, which is 6% of the gross estate.
Excluding 5 million pesos for the standard deduction.
deductions, yes. And then, apart from the legal requirements or apart from the documents, if there are any real properties involved, well, attach also a certified true copy of the real estate involved.
So let's talk about some complications. What happens if one or two of the heirs are not indicated or included in the extrajudicial settlement of estate? What is the recourse of that excluded heir?
So in that scenario, there is already a preterition. That's what we called it. So the heirs are, or some of the heirs are excluded from the extrajudicial settlement. Under the law, they can go after or question the extrajudicial settlement within a period of 2 years. Because after the extrajudicial settlement has been annotated, or that there is already a new certificate of title that has been issued in favor of all the heirs, the Register of Deeds will annotate at the back of the title an encumbrance or annotation saying that this is without prejudice to the rights of the heirs under
Rule 74.
Yeah.
How about the criminal case? Is there a criminal case involved if the other heir is not included in the extrajudicial settlement of estate?
Well, yes, because if remember the extrajudicial settlement is a notarized document. When you mentioned or did not disclose that there is actually an heir and he or she has been excluded therein, you will have a criminal liability for falsification of a document.
So is there any instance that you can ask for the annulment of the extrajudicial settlement?
Yes, you can always go to the court and have that extrajudicial agreement declared as null and void, along with other courses that you can take against the other heirs or against the buyer if the property has already been conveyed to a different person.
So you mentioned real estate being included in the extrajudicial settlement of estate. What other properties can be included?
You can include their personal properties, of course. You can also include if there is any shares of stocks of a corporation, include that there.
How about bank accounts?
Yes, bank accounts, cars,
Paintings, personal property, jewelry.
yes, include everything.
Okay, so why would you opt to do extrajudicial settlement of estate versus judicial settlement of estate?
Well, for this extrajudicial settlement, definitely it will save you time
Mhm.
and cost also of money. It between the parties. If you go to the judicial or judicial settlement of the estate, you will have to file the filing fee of the court, legal fees, and other fees, on top of the payment of the estate taxes.
Can you combine another transaction with an extrajudicial settlement of estate?
Yes, of course, you can do that. If the parties would want to convey, say, some part of the real estate of the deceased, you can combine it with the extrajudicial settlement agreement with deed of absolute sale. Even if you want a deed of donation, you can also do that.
So now you've executed the physical copy of the extrajudicial settlement of estate, and then you've tried registering the first property with the registry of deeds. And then you've lost, well, not really lost, you've used up your copies already. For the succeeding properties, say you have 10 under the extrajudicial settlement, what can you do? Actually, it is necessary that the BIR would stamp the transaction in the extrajudicial settlement of estate. And then, once you have completed the annotation for the Rule 74 under the Extrajudicial Settlement of Estate and the names are already transferred under the heirs, you should be getting multiple copies of the Extrajudicial Settlement of Estate through the Registry of Deeds. It would be just like, it will look like a security paper, just like any title. And then can use that in the multiple properties that you'd like to register the Extrajudicial Settlement. So what if the heirs are outside of the country? Can they still execute an extrajudicial settlement?
Special power of attorney, they can execute by authorizing or appointing another person in their favor or in their behalf to sign the extrajudicial settlement. Or what they can do is also have that portion in the extrajudicial settlement notarized and apostilled or legalized in the country where they are residing.
So essentially, when you register the extrajudicial settlement, the process is more or less the same when you transfer a title. You have to also go through the BIR because you need to pay for the estate tax.
Yes.
And then you have to go to the city hall to pay for the transfer tax. And then you also have to go through the registry of deeds to cancel the old title under your predecessor's name and leave it under the heir's name. And then go back to the city hall to cancel the tax declaration under the predecessor's name and put it under the heir's name. So this assumes everything is divided equally, meaning everyone is a co-owner of all the properties that were left behind. Is it possible that they pick and choose already in their extrajudicial settlement of the estate who owns what?
Yes, they can actually do that. So say if there's 5 properties and 5 siblings, they can choose whatever they want among themselves.
Yeah, that's interesting because others don't know that, and they could easily just put it under their name so that they don't have to, every time they sell, they don't have to ask for the permission of the other heirs.
General default will be all their names will be included in that one title alone.
Correct.
It's very difficult along the process if they eventually, sell the property or dispose it to somebody.
So when should you execute your extrajudicial settlement of estate?
Well, it is advisable to execute it ASAP or immediately after the death of the decedent or after you have, after the burial and everything. Because you have a period of 1 year from the time of the death of the decedent to file the estate tax return before the PIR.
Yeah, otherwise you're looking at penalties and interest.
Yes, penalties.
So how about an instance where there is financial hardship? Can you ask this to be extended?
Well, the commissioner can grant the authority or has the authority to grant an extension within which to pay for the estate taxes. So the payment of the estate taxes is 6% on the net estate. So excluding already the standard deductions of 5 million there.
Right. So, okay, is there any other tips when you execute an extrajudicial settlement that you would want to impart to our listeners?
So we would suggest that you get a guidance from the one who actually knows how the process is. Because there are some certain documents that the BIR will have to request from the parties, and that the heirs doesn't really know where to start with, or how to get that document, or where to get those documents. So if you have any lawyers, yeah, sure.
All right. Thank you for listening.
Bye.
Bye.